Hi, it's Roxette here. Today we are going to speak about an evil that is a scourge around the world and seemingly increasing all the time. We are talking about domestic abuse, which year by year is getting more serious and happening more often in Ireland. Jennie's's Law is a proposed new law in Ireland which, among other areas, is aimed at helping people stay safe in relationships by making certain domestic violence convictions more visible to the public. It is named in memory of Jennifer Poole, who was murdered in 2021 by her ex-partner, Gavin Murphy. After her death, her family learned that Murphy had a history of violence against women, including previous convictions for assault and a prison sentence for attacking a former partner and her mother with a knife. Murphy received life imprisonment, but that will not bring Jennie back from a horrible death that could have and should have been prevented. The central idea behind Jennie's's Law is simple. If people had access to this kind of information earlier, they might be able to make safer choices when entering into new, intimate relationships. Our law at the moment uses the term domestic violence. It is perhaps more useful to use the term domestic abuse, as people tend to link the word violence to physical acts, whereas domestic abuse as a concept goes much further than that, recognizing that there are many non-physical ways to make a person's life a living nightmare. The official name of the proposal is the Criminal Law, Sexual Offences, Domestic Violence and International Instruments Bill 2025. It is important to know that a bill is not law. It has to go through a number of different stages before it becomes an act. And even then, the act only becomes effective law when the minister decides to put it into operation. So we still have a long way to go. If passed, the new law would create a public online register of certain domestic violence cases. This register would be hosted on the Courts Service website, courts.ie. The register would contain written judgments when attackers are convicted of serious offences involving domestic abuse. These published judgments would include details such as the offender's name, the offence, and the sentence handed to the offender. The online register would be accessible to any member of the public. However, publication would not be automatic. A judge would have to decide whether to publish the judgment, and the survivor of the abuse would also need to consent to the publication of the judgment. At the moment, information about domestic violence convictions is not easy to find. In most cases, offenders are only publicly named if their case is reported in the media, or in the extremely rare case that a written judgment on the subject of domestic violence is published. Judges already have general powers to control what is reported in court cases. For example, they can limit media coverage or exclude the public in certain proceedings. But there is currently no dedicated system focused specifically on domestic violence cases that makes this information consistently accessible. Jennie's's Law would change that by creating a central, searchable register. Jennie's's Law has often been compared to the UK's Clare's Law, the Domestic Violence Disclosure Scheme, which has created an accessible register of offenders convicted of crimes involving domestic abuse. However, it is very important to realise that Clare's Law goes a lot further than Jennie's's Law in its current form. Clare's Law contains two important features. The right to ask. A person can request information from the police about a partner's history of domestic violence. The right to know. Authorities can proactively warn someone if they believe they are at risk. These features are not included in the current Irish proposal, despite calls from support organisations to adopt them. In addition, there are several important issues that need to be resolved before this new law comes into operation. 1. Lack of clear guidance for judges. It is not yet clear how judges should decide whether to publish a case on the register. There are no detailed guidelines explaining when publication is appropriate, or a list of factors a judge must consider in deciding whether to publish the judgment on the register. This could lead to inconsistent decisions from case to case, which in turn would undermine public confidence in the law, and this would damage the efficiency of the register. 2. The sequence of events. There is also a practical concern about this publication process as it stands at the moment. A survivor must first agree to publication, which can be a difficult and emotional decision, especially in a small country like Ireland, where it is a distinct possibility that the survivor will be identified from details in the judgment. However, even after enduring this secondary victimisation in coming to the decision to give consent, the judge may still decide not to publish the case, meaning all the pain on the victim's part was for nothing. A more straightforward approach, consistent with current practice, might be: the judge decides first if the case is suitable for publication, and the survivor's consent determines whether it is actually published. 3. Limited range of offences. The register would mainly include details of offenders convicted of serious physical and sexual offences, such as murder and manslaughter, rape and sexual assault, coercive control, serious assaults, for example, causing harm, strangulation, threats to kill. However, this limited list raises concerns. Domestic abuse is not just physical harm. It often includes psychological abuse, emotional manipulation, financial control, technology-based abuse, such as tracking or harassment. These forms of abuse often leave no visible injuries, but can be deeply damaging and harder to prove in court. Under the current proposal, many perpetrators of these types of abuse may never appear on the register. There is also a notable omission. Repeated breaches of domestic violence orders are not clearly included. Jennie's's Law represents real progress. It acknowledges the importance of access to information in preventing domestic abuse and gives the public a new tool to protect themselves when considering entering into a new relationship. But it is also a limited measure. If the proposed Act does not authorise broader disclosure rights, like the UK system, it is not protecting many people by not allowing them to access vital information when considering a new partner. If the proposed Act does not provide clear guidelines for judges regarding publication on the register, this will result in conflicting decisions, which in turn will destroy public confidence in the new measures. Finally, if the proposed Act does not exhibit a wider understanding of what domestic abuse in our current society entails, its impact may be less than hoped, and the opportunity to educate members of the public about the many forms of this hidden evil will be lost. As it is still a bill, Jennie's's Law is an important step forward, but I pray that it is only a first step. The question now is whether Ireland is willing to go further and create a system that fully reflects the realities of domestic abuse today. This is Roxette. Please be careful and stay safe out there.